Hi guys, welcome in IPC lecture 2. We just covered the lecture 1 where we discuss about the elements of the crime and the importance of intention and the stages of the crime, basic definitions of the crime. Now the next discussion which is ongoing. In this we will talk about the comparison of IPC points with tort, because if you see in tort there are certain concepts which are equally present in IPC, but the interpretation and the legal meanings of those terms are a bit different when we speak for the same term in IPC, which is in criminology, and the other one in tort. The points here, what we are going to cover in today's lecture is strict liability. You have heard of strict liability in tort, but today we'll discuss about the concept of strict liability in law. Then the basic comparison between what is crime and what is tort. So the basic points which will help you to understand and further study both the subjects. So, and the third one is vicarious liability. Vicarious liability, which is owner's liability, it is an important concept in tort, but we have to see that what are the roots of this subject, because it has been originated from IPC. So our discussion today is limited to 3 points. One is the difference between crime and tort, the basic points of difference, the basic differences, and then the two concepts which are generally the part of tort, which is strict liability and vicarious liability. But today we'll see what is their interpretation in terms of IPC. So the first point which I would like to start is the difference between criminology, which is crime, what is the crime and what is the tort. So if you see the basic points, the difference between these three is that a crime, generally it hampers the social order. It is related with the social order because all the offenses in IPC, they are taken on the name of a state. So once there happens a crime, the state comes into picture and all the litigation is being done between the accused and the state. So all the judicial proceedings is taken on the name of state. While in the tort, it is related with the individual, the acquisitions of individual in terms of the society. So at one place in crime, the state takes the lead, while tort is considered as an offense against the society. It's not limited to a particular contract or particular responsibility, but it is general, in a general perspective, towards the society. Then another important point is crime, generally it is established that the crime generally happens because of intention, as we seen in the last lecture also, while tort, it is assumed or presumed that in tort the offense generally happens due to the negligence of a person. Then the result in crime is punishment, because if anybody does anything, he gets a punishment that can be of any type. It can be a imprisonment, it can be a death penalty, it can be a forfeiture of the property, it can be fine, it can be anything related to the standard types of punishment which are present in the IPC, which we will see in the future. So here the result of the proceedings is the punishment, while in tort there is nothing called punishment, it is compensation. So any offense in tort, it is redressable only with a compensation. You will get a compensation if you have any injury, legal injury in terms of tort. For crime, we go to criminal court, while for a tort, we go to a civil court. It's a civil proceedings, and as you are aware that in crime, everything is codified. There are statutes, there are acts. Based on that, it is done. Although there is a common law procedure based on the previous case laws, it is there, but the source of litigation is the codified law. While in tort, there is no codified law. Tort typically works on maxims and the case laws. So that is another difference. Then in crime, because it is codified, based on the codified law, it all the damages are liquidated, all, which means all are determined, all are based on the statutes. While in tort, as I said, there is no particular statute. It's all governed with the maxims and the case laws. So the remedy here is unliquidated. That is another difference, that in criminology the remedies are liquidated, while in tort these are unliquidated because it is uncodified law. Then very important point, that the crime, there are two elements, which is mens rea and actus reus. So crime is dependent on both the factors, although mens rea plays a vital role, it is more important than actus reus, but in criminology both of them are deciding factors, while in tort the deciding factor is only action. Although there is a specific branch of tort, which is specific torts, which talks about the mental element also, but in general, apart from that specific torts, tort only deals with actus reus, means the actions. So these are the basic differences between crime and tort. Now we would like to see the concept of strict liability. So, strict liability in tort, we know that it is a no fault liability of a person, or we can say, uh, actually, in tort, no fault liability is of two types. One is strict liability, one is absolute liability. Strict liability and absolute liability, there is only one difference, that strict liability is based on, it's subject to general defenses in tort, while in absolute liability there is no defense. That is a prime difference between both of them. Strict liability in tort, which is originated from the famous case of Ryland versus Fletcher. It basically holds the owner liable, but it is restricted to certain cases, and that the base of those cases, in this famous case, Ryland versus Fletcher, Justice Blackburn, he decided that for a strict liability case, the master or the owner is liable, despite of free contractor having the freedom to execute the work as per his procedures, but ultimately the owner is liable, because it is related to those cases where the owner brings a hazardous substance of escaping nature for non-natural use. So Justice Blackburn, he determined these 3 points for determining the strict liability, that if any person he brings any hazardous material for non-natural use, and that material is of escaping nature, then any offense related to that use of that hazardous equipment, that will be counted as a element of strict liability. So in this case also, Reliance versus Fletcher, there was a artificial tank which was made and water was filled and there was a leakage. So the result was taken that it is a mistake of the free contractor, so he should be liable. But Justice Blackburn, he determined in this case that although it was because of the work procedures of the free contractor, but ultimately the owner is liable, because in that case he is using a hazardous material, which is water, which is of escaping nature, because you are storing it in a tank which is subject to leakage, so that is escaping nature, and it is for non-natural use also, because nobody collects gallons of water for a natural use in a field where other persons are also living nearby. So that is why in that case it was determined that the concept of strict liability is applicable to 3 important points, that if any person brings a hazardous equipment or a hazardous substance of escaping nature and for non-natural use. So that is the strict liability in tort. But when we come to the crimes, the strict liability concept is considered or viewed in terms of mens rea. So it says that crimes which are not requiring fault of anybody, if somebody is not at fault, there is no mens rea or there is a partial mens rea related, still he is held liable for executing a crime. That is the concept of strict liability in criminology. The necessity of mens rea or negligence is wholly or partially excluded in the case of strict liability in IPC. I am repeating it, that the necessity of mens rea or negligence is wholly or partially excluded in the case of strict liability in IPC. So here it means that the person who is held liable under strict liability, he is liable to have punitive sanctions despite of the lack of mens rea. So here intention plays no role. So now let's see in what cases this strict liability in IPC is applicable. Can you think of some cases where the mens rea is not playing any role? The person's intention is not playing any role in IPC, because we just discussed that it is important in criminology that the intention is important. But now I'm saying that for strict liability, intention plays no role and he is still liable. So what may be such cases in IPC? I can give you the example. The one case is bigamy. So section 494 of IPC talks about bigamy, and this says that a bigamous marriage, irrespective of an intention, is an offense. Whether you want or not, whether you do it intentionally or not, but if you are committing a bigamy, you will be held liable as per section 494 of IPC. So this is one case where the intention plays no role. There are other cases also, which are statutory offences of minor nature or public welfare offences also. Like if you see a violation of any road traffic, your intention plays no role. If you are violating a road traffic guideline, you are subjected to penalty or fine or punishment, whatever you say. But in that case, your intention plays no role. Similarly, if you are selling some adulterated food, you cannot say, I don't know about it. You are selling it, it means you are liable. Okay, so such small offenses in where I have just illustrated that there is there is no need of proving the intention. These are the minor offenses, or these are like bigamy and others. These are the typical offenses where, irrespective of your intention, you will be liable if you are committing these crimes. So such crimes are considered as are considered under the strict liability. So another important concept here is vicarious liability. So in tort, what is vicarious liability? It is owner's liability. So it may be owner. Actually, in tort there are certain relations, like there may be an owner or service provider. There may be a master or servant. There may be an agent or partner. So there are various relationships which are covered in tort, and this concept of vicarious liability is applied the way the relation is. If you see, apart from tort, like apart from a special relationship, the vicarious liability is seen in the cases of ratification also and abatement cases also. For example, ratification, if a master, he says to his servant, don't do something, but he does, and he pays him for that service, so it means he's ratifying his work. So this is another fashion in which vicarious liability can be arrived, that the master says to his servant, don't do it, or he don't see it, but he pays for getting that service done. So with this way, like with the ratification, he accepts, he is held vicariously liable. And there may be some amendment cases also, but for tort, if we go to tort and see what is vicarious liability, it is typically governed with the relation. There must be a relation between the persons so that the owner can be held liable, and those relations, as I said, will be agent or partner, owner or service provider, or master or servant, any of them. Okay, then vicarious liability in tort says that such person who's directing the other person to do some job, he will be liable, subject to there must be a relation between them, and the servant, he does that job in the work hours or in the authorized duty hours. And the third important point is that the master has authorized him to do so. So, but in some cases in tort, the authorization of master is not that important. There is a liability for, there is the vicarious liability on the part of the master, even if he has not authorized that work. Because in such cases, the second condition prevails, that the work is done by the agent or the servant during the official working hours. So there are various cases in that. One is State Bank of India versus Shyama Devi, and then there is one case from UK law, which is Lloyds versus Smith, where this the importance of offense during the work hours is seen. So that is the concept of vicarious liability in tort, that the master is liable for the work of his servant if he is giving him the command, or if he is authorizing his work, he is ratifying his work, although it is subject to certain exceptions. So, but the concept of vicarious liability in IPC is a bit different. Here, the idea, although the soul of the term is same, that the responsibility of the person who's guiding the person, who's directing the person, it is there, but the responsibility here is the criminal responsibility, not the responsibility in tort. So, and here there is one more extension, because there we are talking about the master and slave as a relation, but here we, in criminology, sometimes we talk about the family relations also. And there is a famous quote with relation to that, that the idea of punishing the entire family for the act of any of its member, if criminology goes for that, it is barbarous, but it is based on a principle, and that principle is called the principle of solidarity of guilt. So, as per the principle of solidarity of guilt in IPC, any of the family member of the offender can be held vicariously liable for the offense. Although it is subject to criticism, it is subject to case laws and various jurisdiction, what they have to say, but that is typically the idea. Now there is a famous case in UK's law, which is R versus Huggins. It is 1730 case. It is a very old case. Now I'm going to tell you the facts of this case, and then you see what it is. It infers. It infers to the vicarious liability only. In this case, there is a deputy warden who was accused of murder of a prisoner by keeping him in a filthy room, while the warden has seen him doing so. So the deputy warden kept the prisoner in a filthy room and he died, and the warden has seen this. So was the warden be held liable for this in vicarious liability? Answer is no. Why? Because he is not liable, because it was not done as per his command. Neither he has directed nor he has given any consent. So it's not as per his instructions. He has just seen it. And it was not his legal duty to stop this, because deputy warden was executing his duty. So it is again debatable, because the warden could have stopped him. Then that must be his ethical responsibility, but not the legal responsibility. So hence we can say that in common law rule, no person can be held vicariously liable for the wrongs committed by someone else unless he has previously authorized that job or assented or gave his consent for that job. So that's why in R versus Huggins case, the warden was held not liable under the vicarious liability. So if you see the case law in tort, there's a huge case law on this subject, which is vicarious liability. But in IPC, this is a prime case where we can see that how the person was not responsible because he has not assented for the act. Now, as there are certain defenses in tort for the vicarious liability, there are some exceptions in IPC for vicarious liability also. That includes the cases of libel. There is an act which is 1843's Libel Act. The section 7 of that act, it allows any proprietor to he can make a plead for the absence of his knowledge or negligence in his defense, and he can say that the libel was issued without his authority. So this is one exception in the case of libels, that the publicator, the proprietor, he can seek lack of knowledge, his negligence, and without his knowledge, without his approval, the libel was published. So this is one example or one exception in the case of libels where the person can seek the exception from the vicarious liability. Then there are other exceptions related to public nuisance, and especially the contempt of court. There are exceptions. There is a section 11 of Administration of Justice Act 1960. So any accused for the case of contempt of court, he can take an exception based on this, and he can say that it was his lack of knowledge about the court proceedings and hence he could not join those proceedings. So this is another exception for his liability, vicarious liability, where we can see an exception. And apart from that, there are various statutory exceptions also. So based on these exceptions related to libel, contempt of court, public nuisance, and other statutory exceptions, subject to these exceptions, vicarious liability, if you can say, the crux is same as of tort, that is, it is the owner's liability or the person who is giving the instruction his liability. Although in IPC, apart from various relation, we can see that the family relations are also dragged in case of vicarious liability on the principle of solidarity of guilt. So with this, I would like to wind up this topic, and in the future topics we will be seeing, which is IPC 3, we will be seeing the common intention and common object. We will discuss about that in relation to IPC. Thank you.